Good afternoon, everybody. Cracking on with the next segment of the Dudes chat with Dr. Richard Leo. And Richard Leo was just talking about the judges, basically. And we're just about to get to the question of, the difference between a federal judge and a state court judge. So let's see if I can share that with you. Share sound. Richard Leo. Click on that. Get rid of me. Make that bigger. And I think we're just about ready to go. Here we go. Richard Leo is talking just at the moment, as I say, about judges.
And we don't want unreliable evidence to go in front of the jury.
Right.
Yeah.
And, you touched on something there. I mean, when I had retired FBI agent Steve Moore on, he was talking about how if he had taken the case that Wiegert and Fassbender had built against Brendan, and he was walking into federal court with that he would have gotten laughed out and might have possibly been sanctioned. Like, that's what he says would have probably happened if he carried that into federal court as an FBI guy. And it makes me wonder about the different standards. I mean, the state courts seem to kind of have a bit of a lower bar than the federal courts. Have you kind of experienced that or noticed that?
Well, I've worked on far more state cases, and
Right.
the state cases, of course, most cases in the United States are state cases, very few are federal cases.
Right.
I do think there's a higher degree of professionalism, of attorney competence, of discourse, more written materials, a deeper dive into the issues in federal court than in state court. So you could say, in a sense, the federal court has a higher bar, the state court has a lower bar.
Right.
In the United States, federal judges, of course, have lifetime tenure. And so I've also seen a lot of very arrogant and condescending and abusive federal judges. We joke they sometimes get black robe fever or judge-itis, whereas I've seen more kind of incompetent ones at the state level. I would agree. I think the practice of law is pitched at a higher level. I think Zelma might have a question or a comment. I'm not sure.
I do. And I don't want to take this too far off topic, but my issue with teenagers is this. If we were to flip the situation and let's say that a child victim has disclosed that a crime has occurred, sometimes there's even evidence that crime has occurred, but the child isn't fully consistent in their statement in an interview that was very open-ended and allowed the child to do all of the descriptiveness. Unless there's a slam dunk case, often they say, well, the child's too young or the child's unreliable, and they'll come up with all of these excuses not to take the case based on the child's statement, even if the statement's wonderful. But then we've got Brendan, who gave a crappy statement, inconsistencies all the way through, and then they push that forward. And then if we continue on, if that child's case is taken and in the courtroom, the child says, wait a minute, I recant, I wasn't actually abused, or that didn't actually happen, they will throw that case out because now the child's definitely unreliable. They've changed their statement again, right? So what I would like to see, what I think is the only way to make this work fairly for youth, is at the judge level, they need to be trained to understand the way children think, the way children talk, the way children understand questions, the way they communicate, right? Because we can't treat children like adults if they're victims, and we can't treat children like adults if they're perpetrators. Even a perpetrator who's a juvenile did it for a different reason, possibly, than an adult offender. And so This just angers me to no end. Even if Brendan had done this, he didn't get a fair shake. Even if he had done it.
Even if he had, yeah.
Which he didn't.
But,
can I just make a comment?
Sure.
I agree with what everything Zelma said, but doesn't that actually come down to good old common sense, right? If you look at, I know you can't apply common sense to Fassbender and Wiegert, but surely over all the interrogations that they've done, they knew that what Brendan was telling them was completely wrong. He was making everything up.
Particularly when he told them straight up, I've been guessing the whole time.
Correct. So the question is, was Brendan Dassey a mere pawn in the game? That their ultimate goal was to nail Stephen Avery, because this case is unique in terms of there were two people on trial for the murder of one person. And the way the trials were treated, you think that there were two victims and two crime scenes. Right. So in effect, the way I see it, Dr. Leo and Zelma, is that Brendan Dassey was collateral damage. He was a victim of the system. Their true aim was to nail Stephen. And remember, it was Brendan who walked into the bear trap, right? He walked into the bear trap because, as Dr. Leo said, had he had proper legal representation, right. For example, if Kathleen Zellner was sitting next to him, Brendan would not be in that predicament that he is now.
I think if he had Die Rider sitting next to him back then, he probably would
have
been right.
Even that. Correct.
Or if Kathleen Zellner had been representing him at trial, even if he had falsely confessed. So as you know better than me, he didn't have very good trial representation.
Right. No.
Are you a homeowner aged 51 or over and struggling with debts over 6K? Did you know that as a...
Probably could have been better, certainly. So one thing I wanted to ask about, and it was in your answer to Dr. Silkman earlier, you were touching on, the contamination coming from detectives and that sort of stuff there. I wanted you to go ahead and talk about the scientific principles that you apply, where you talk about the fit in your paper, and how you talk about taking what the person is actually saying and in the so-called confession, and then fitting that to what we actually know about the scene or the facts of the case, and determining how reliable they are from that. If you want to talk a little bit.
Sure. Well, you see a pattern in true confessions, a pattern in false confessions, that the narrative that the suspect gives reveals non-public, not likely guess by chance knowledge if it's a reliable confession, absent contamination, right, if it's taken properly, that the person knows details that are not likely guessed by chance, that they can lead police to new or missing evidence, that things they say will be corroborated by medical and physical and other credible evidence. And then the opposite in false confessions. They don't know details. They're guessing, as Brandon did. They're getting facts wrong, as Brendan did. They can't lead police to new or missing evidence or fill in any of the blanks. That the existing evidence, and I'm not talking about other testimonial evidence, but I'm talking about physical, medical, DNA, forensic, doesn't fit or match the confession. That's the pattern that you see in the false confession cases. And so the narrative, the confession narrative, doesn't fit with the facts of the case, the evidence. The suspect doesn't have the inside, non-public knowledge unless it is fed to them by the police, or was in the public domain, or they knew from one of their friends, or they guessed by chance. And so you see very distinct patterns. And this is what we call indicia of unreliability, which is different from the risk factors for false confession. So if you coerce somebody, as Brandon, I think, was psychologically coerced, that doesn't necessarily mean the confession is false. It means that the interrogation created the risk of eliciting a false confession.
Right.
But when none of the facts match, when the person doesn't know the details, when there's no evidence corroborating, this becomes stronger indicia of unreliability.
Sure, absolutely. Okay, Mr. Capaldi, it's your turn.
Well,
I do have one more question, obviously, and I think everybody knows what that question is.
Absolutely.
So we'll save that one for the end. But
sure. First of all, Dr. Richard Leo and all the guests, thanks for joining in.
It's brilliant.
Particularly to Richard Leo for replying to my email when I asked you about the false confessions in the 21st century, and that was the article you did with Stephen Drizzen. Now, we as in the dude and Mark and myself, we went all the way to Melbourne, Australia, believe it or not, to give Steve Drizzen a Brendan Dassey T-shirt about the control question. But what I was wondering is if you could tell us a little bit about your involvement with Steve Drizzen, because he's Chicago and you're California. You know, it seems a long way apart to be working together. But also, you mentioned that you'll be doing another collaboration, looking at confessions.
So I've known Steve now for over 20 years. I had gotten my PhD in 1994, and I started studying interrogation and confessions in 1990 when I entered graduate school. I became professor at CU Boulder in 1994, and then I left for the University of California, Irvine in 1997. And I had started publishing articles on my own with Dr. Richard Offshee, a Berkeley professor, now retired. And I think that in the late 90s, this is my memory of it. Steve may have a little bit of a different memory. I think Steve reached out to me. He was a clinical law professor at Northwestern, and he was trying to educate himself on police interrogation and false confessions. I think at that time he might have had a listserv where he was reaching out to a lot of people and disseminating information through large email lists. I remember going to Chicago. I think it was 1999. There was a bill before the Illinois state legislature. I think it was created by a state senator Barack Obama, who nobody had heard of at the time.
Sure.
And I remember testifying in front of a committee where I met with Steve beforehand, and then we both testified in front of this committee. But actually, come to think of it, there was a conference at Northwestern, a very famous conference in 1998, November of 1998. And I remember I knew Steve then too. So that was the conference put on by Larry Marshall, Northwestern Law School, on the death penalty, where famously a number of people who had been released from death row because of doubts of their innocence came onto the stage and said, my name is, fill in the blank, Kirk Bloodsworth, Gary Galber, etc., Randall Dale Adams. I was sentenced to death by the state of X, and had I not been freed, I would have been executed. Very powerful, very moving. So Steve and I knew each other at least since 1998, possibly earlier, and started collaborating on the article that I think you were referring to, one of them, where in 2004 we had 125 proven false confessions. Now there's 4 ways you can prove a confession false or almost absolutely false. If you can show that no crime occurred, the murder victim shows up alive, for example, but there are other examples. If you could show that it was physically impossible for the perpetrator to have committed the crime, say they were in jail in another state at the time.
Right.
If you could show there's dispositive physical evidence, often but not entirely DNA evidence, that proves they didn't commit the crime, or if the true perpetrator is apprehended, everyone reasonably agrees that person's the true perpetrator.
Right.
So we found 125 cases like that, and we analyzed patterns in the cases. And the article got a wide reception. It was cited by the Supreme Court in the United States. It's been downloaded many times on SSRN.
Booking a Verbo holiday home means leaving all the craziness behind. Well,
we've been working for years on another article which has 250 proven false confessions. We're almost done with the data coding and analysis, and I need to write that up. So there's been a delay. But that will be a powerful article in the sense that it'll be the biggest sample of proven false confessions. Now, this is different from exonerations. First of all, the National Registry of Exonerations, they use legalistic categories. If somebody's conviction's been reversed and there's some evidence of innocence, though they never specify how much, they put it up there. But all those cases are convictions. Our cases aren't all convictions, and our cases aren't legalistic. We're saying these are cases where we can prove the confession false.
Right.
So it's a different data set. It tells us something different about the criminal justice system and false confessions, although a lot of the findings might overlap.
Sure.
Steve Drizzen is a great lawyer. He's a great storyteller. He's a good writer. He now has a podcast. He is not a social scientist. I'm a social scientist. I'm not a great storyteller. I don't have a podcast. So we are complementary. So we form a good working relationship, I think, because we bring different strengths to the table.
Right. I love Professor Drizin. And we went all the way.
I think we'll stop it there and look forward to the final part soon. One thing I did want to mention, let's just close this down and stop share. There we go. One thing I did want to say was that obviously Richard Leo's book is called Police Interrogation and American Justice. And it's only available as a hardback copy, so it is quite pricey. I was lucky enough, I think, to get one that had been in a library, and obviously after a certain while these get removed. And this book, as I say, by Richard Leo, Police Interrogation and American Justice, was printed by the Harvard University Press in 2008. Now, obviously, a lot of you will know the lawyer Mark Godsey of the Ohio Innocence Project, who's also written famously written books on the subject. So what I wanted to share with you was that there's a Blind Injustice was the Richard Leo Mark Godsey book, Blind Injustice, where he talks about the in effect the corruption of prosecutors, and the connection between Richard Leo and Mark Godsey is that Richard Leo's book actually was reviewed in the Ohio State Journal of Criminal Law in 2009, and I will leave the link below to this article by Mark Godsey, a review of Richard Leo's book. I have done a video about it already, but I'll put the link below. I remember in particular at the end, towards the end of the article, Mark Godsey's suggestions for improvements to the Miranda rights. One of them being that, well, the two in particular were a fifth part to the Miranda warning, stating quite clearly that if you decide that you don't want to say anything, then that will not be taken as some sign of guilt, and you will not be sort of treated in a different way if you choose to exercise your Miranda rights. But the other thing that he said that was very, very good was, that what they should do is before they interview, particularly juveniles, is to have a short video, so that Miranda warning isn't something that's read out by the police interrogators. They actually sit in front of a video, and the judge explains in this video exactly what the Miranda warning is all about. It would only take a couple of minutes, but it would be a great way of making sure that when particularly juveniles such as Brendan are about to be interrogated, they know exactly what it is that they are waiving if they decide to waive their Miranda rights. Anyway, I'll pop that in the link below, and hopefully it won't be long now before we get this new filing from Kathleen Zellner, and we can dive into that. But this is part 3, part 4 yet to come. And obviously you can tell that obviously we finish off the chat with Richard Leo talking about the control question. Well, what else is there to talk about? I mean, seriously, come on. Right, okay, we'll catch you all soon. Take care. Bye for now.